Mr. Boxman, you may proceed.
May it please the court, counsel. States 15. This is Sade Dixon in life. She was a daughter. She was a sister. She was a mother of two and soon to be mother of a third. This is Sade Dixon before that fateful evening of December 13th of 2016. Before that man decided to drive to her house, get out of his car, and start shooting. States 25. This is Sade Dixon after that man murdered her and her unborn child. After that man decided to shoot her over and over and over again. After he riddled her body with bullets and shot her 8 different times. Sade Dixon and her unborn child are dead because of Markeith Loyd. As the judge just instructed you, the defendant is charged with 5 different counts, each with a different victim. Ladies and gentlemen, the facts of this case are not very complex or complicated, and many of the facts aren't even in dispute. I'm going to spend some time going through the facts and how they relate to the instructions the judge just read to you and that you have before you in your packet. Because the first 3 counts deal with the murder of Sade Dixon, her unborn child, and the attempted murder of Ronald Stewart. They are very similar and they carry a common element of premeditation, which we will talk about in a little bit. I'm going to address those kind of collectively. The judge indicated as far as count 1, murder in the first degree, that the state has to prove 3 different elements beyond a reasonable doubt. Number 1, Sade Dixon is dead. This is not in dispute, ladies and gentlemen. Everyone agrees that it was Sade Dixon that was shot and killed at the front lawn of 6031 Long Peak Drive that evening. Her body was taken from the scene by a transport unit. She was taken to the medical examiner's office where Dr. Sarah Zadovich performed an autopsy upon her. Dr. Zadovich went through the 8 different gunshot wounds and the damage that each projectile did as it entered her body. She explained how Sade Dixon was shot in her arm, her left breast, the back of her leg, her left thigh, and her foot. And she told you that her cause of death, the cause of death of Sade Dixon, was multiple gunshot wounds. The manner of death was called a homicide. This element's been proven beyond any reasonable doubt. The second thing the state has to prove is that the death was caused by the criminal act of Markeith Loyd. It is not in dispute that the defendant was the person who shot and killed Sade Dixon. You heard him admit that on the stand. Various witnesses identified him as the shooter as well. You also heard that 11 different .40 caliber shell casings were located at the Dixon house. They were collected by crime scene investigator Andrew Harrison. And on January 17th of 2017, a little over 2 months after these murders occurred, the defendant was arrested and a .40 caliber Smith & Wesson handgun was recovered at the house near him at the time of the arrest. That firearm was sent to the Florida Department of Law Enforcement Firearms Lab, where analyst Richard Ruth analyzed the firearm, compared that firearm to the casings that were found at the scene, determined that same gun fired those 11 casings at Miss Dixon's house. During the autopsy, Dr. Zadovich also recovered a projectile from Sade Dixon's arm, which was sent to the Florida Department of Law Enforcement, and Richard Ruth analyzed that projectile and determined it also came from the defendant's firearm. The third element the state has to prove is that there was a premeditated killing of Sade Dixon. And we're going to get into premeditation in a little bit. Count 2, as the judge read to you, deals with the first-degree murder of Sade Dixon's unborn child, and it's very similar to the first count. The state has to prove, number 1, that her unborn child is dead. You heard from various people that Miss Dixon was pregnant. The defendant acknowledged he knew she was pregnant. You saw a sonogram video of Sade Dixon's baby boy. At the time they didn't know that, but her baby. Heart was beating. According to the sonogram video, baby was healthy. During the autopsy, Dr. Sadovich also performed an internal examination and confirmed that Sade Dixon was pregnant. And by the measurement of the fetus, the unborn child, the child was about 3 months along. Now, ladies and gentlemen, there is nothing in Florida law that requires the state to prove that the child was viable before the defendant can be convicted of this crime. There's nothing that requires proof that the child was able to sustain life outside of Sade Dixon's body. There's nothing in the law that requires the state to prove some threshold age of development before the defendant can be found guilty of this crime. Several jurors during jury selection talked about their personal opinions about whether or not they felt that the child should be viable or the child should reach a certain stage of development. And that's the juror's personal opinion, maybe some of yours. However, each of you in jury selection agreed that you would follow the law as the judge instructs it and not require the state, not require Mr. Ridgway or I to prove something more than what the law requires. And there's nothing in the law that requires any additional proof that the child was viable or the child reached some age of development. At this time, ladies and gentlemen, at the time Sade Dixon was killed, Sade Dixon's unborn child needed Sade Dixon to be alive to sustain life. This element's been proven beyond a reasonable doubt. The second element the state has to prove is that the death of the child was the result of the injury to Sade Dixon. That's pretty obvious, ladies and gentlemen, and Dr. Sadovich indicated and testified that because of the injuries and the death of Sade Dixon, that is what caused the death of the unborn child. This element has also been proven beyond any doubt. Third element, the death of the unborn child was caused by the criminal act of Markeith Loyd. Again, we've already discussed that we know the defendant was the one that fired the gun that caused the death of Sade Dixon. And fourth, that Markeith Loyd acted with a premeditated design to kill Sade Dixon, which again, we will get to that shortly. Count 3 deals with the attempted murder of Ronald Stewart. In order to prove that count, the state has to prove, again, 3 elements. 1, that Markeith Loyd did some act intended to cause the death of Ronald Stewart that went beyond just thinking or talking about it. Again, there is no dispute that the defendant was the one that fired the gun that injured Ronald Stewart. He was shot multiple times, once at point-blank range to his chest as he lay on the ground, bleeding from his previous gunshot wound that the defendant inflicted. Obviously, by actually pulling the trigger and shooting Ronald Stewart, that is some act intended to cause the death of Ronald Stewart that went beyond just thinking or talking about it. The second element the state has to prove is that Mr. Loyd acted with a premeditated design to kill Ronald Stewart. And again, we'll get to premeditation in a second. And third, the act would have resulted in the death of Ronald Stewart, except that somebody prevented Markeith Loyd from killing Mr. Stewart, or he failed to do so. Ladies and gentlemen, the only reason Ronald Stewart is alive is because of the medical treatment that was provided to him on scene and at the hospital. The defendant simply failed to kill him. This element has been proven beyond a reasonable doubt. The judge read to you, and it's in your packet, that killing with premeditation, which is the common element of these first 3 crimes. Premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law doesn't fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant, and it must be formed before the killing. Ladies and gentlemen, premeditation does not require long-term planning. It doesn't require proof that the person sat and waited and planned this over days, weeks, months. Legally, ladies and gentlemen, as you can see from the jury instructions, premeditation can happen like that. As long as there was sufficient time for the defendant to form the intent to kill before the killing took place, that is premeditation. Everyone in jury selection indicated that you could follow that law. Everyone agreed that you would not require us to prove some greater degree of premeditation, greater than what the law requires. Let's look at the evidence of premeditation in this case. Number 1, the defendant went to the house with a gun. Well, we know, according to his testimony, he went there with 2 guns. And we know that the gun in the front lawn, at marker 6 of the state's diagram, was the 9mm owned by Sade Dixon. the gun that was found at the time of his arrest, and the gun that fired the bullets and the casings that eventually struck the house, struck Sade Dixon, and struck Ronald Stewart, all were fired from the defendant's gun. That same gun that fired at Sergeant Clayton at Walmart on January 9th.
Overruled?
We know Sade Dixon's gun was never fired. There were no 9mm casings found on this scene. The defendant brought that .40 caliber Smith & Wesson with him to Sade Dixon's house that night. The fact that he brought a gun with him is evidence of planning and premeditation. Let's look at the testimony of Ronald Stewart and some of the other evidence and physical evidence that also shows premeditation occurred in this case. You heard from Ronald Stewart that he was home that evening at the computer in the office working on some job application. He heard a knock on the window or door, saw a light flash or something, and he goes to the door and he sees it's the defendant. The defendant is asking, is Sade here? He goes and he gets Sade. Sade leaves and goes outside, and he goes back to working on whatever he was doing on the computer. About 30 minutes later or so, Ron wasn't sure of the exact time, but sometime later on, Sade Dixon comes back in the house. She goes upstairs. She's up there for a few minutes, and she comes back downstairs. Ron doesn't know exactly what she did, what she got, or what she was carrying when she came back downstairs, but we know what she got. She went up and got the 9mm firearm that was in the locked box in the back of her closet. And Stephanie Dixon Daniels told you that that firearm was kept in that locked box, and the firearm was kept separate from the magazine. Ron Stewart, about 10, 15 minutes or so after Sade Dixon leaves the house the second time, hears some noise or some bump on the garage. Thinking, maybe that's the dog, I don't know what's going on. He gets up and he goes through the interior of the house into the garage door area to check on the dog, and the dog's fine, but he looks out the garage windows that are up top, and he sees the defendant, and he sees his sister near the car area in the driveway. He told you that his sister looked afraid, looked worried. We now know why she looked worried and why she was afraid. Ronald didn't know at the time, but we know that the defendant had pulled two guns on her and pulled the trigger of one of the guns, intending to shoot her, but it didn't fire. Ron Stewart told you, because of how his sister looked, she looked worried. He went back inside, put his shoes on, maybe put a jacket on, went outside to see what was going on. And the path of travel in States 14, diagram number 1, shows he walks out of the house and he goes down the little concrete walkway to see what's going on. And he sees Sade Dixon on the passenger side of that car. He sees the defendant in the back driver's side of the car, that general area. And he starts walking towards them. As he's walking towards them, Ron Stewart told you that he sees the defendant leave that area and start walking away towards the street, towards the end of the driveway a little bit. He sees his sister walk closer to where he was, and Ron Stewart walks closer to where his sister was, and he and his sister are kind of hanging out in the same general area. A decent distance away from the defendant, unlike what the defendant's story was. Ron Stewart told you, he says, what's going on? What's the problem here? The defendant said, nothing, we're just talking. Ron Stewart told you that he said, doesn't look like you're talking too good. You may just want to take care of this a different day. Sade Dixon said, everything is fine. She's trying to keep Ron out of whatever's going on. Ron Stewart says, Sade, you need to go in the house, tells the defendant, you need to leave, get in your car and just leave. We're not doing this today. The defendant, instead, chose to stay. All of this could have been avoided if the defendant just left like he was told by Ron Stewart, who lived there. The defendant wasn't about to leave. He was going to finish what he started. Ron Stewart told you that the defendant accused Sade Dixon of being unfaithful to him. Shadi Dixon responded and said, "Why are you telling him our business? Why don't you tell him about the fact that you just pulled 2 guns on me in the backyard?" Ronald Stewart testified. At this point, he's getting a little more concerned, and he tells, again, Shadi Dixon, "Go in the house," tells the defendant to leave again. "They don't need to do this right now. This is for another day. Let's calm things down." The defendant wasn't going to leave on anybody else's terms but his. The defendant says, No. We're going to talk about this today. We're going to talk about this right now." Shadi Dixon then said, "My brother will beat your ass." Ron Stewart told you at this point he's becoming increasingly more and more concerned, a little worried. At this point, he has information that the defendant has 2 guns on him. Ron Stewart told you he wanted to end this situation, get his sister inside, get the defendant out of there, and move this to another day. Ron Stewart told you, he said, "We're not doing this today." At this point, Ron Stewart tells you that Shadi Dixon, he sees his sister begin to run towards the front door. He looks back and sees the defendant running towards the same direction, to the left, towards that porch area. We know why Shadi Dixon began to run. I submit to you is because the defendant took that gun that he had underneath his armpit and pulls it. That causes Shadi Dixon to run. Ron Stewart follows her. And when they get to the porch, Ron Stewart told you that he looks back. They're at the door. They're trying to get in. He looks back and he turns and he sees the defendant with the gun in his hand. He sees the defendant lift the gun up. He sees the defendant pull the slide back, putting her around in the chamber. And he points it at Ron Stewart. We know at this point Shadi Dixon doesn't have a gun because the defendant has it. We know Ron doesn't have a gun. The defendant even told you on the stand he never thought Ron had a gun. They're not a threat to anybody. They're running away. No one was preventing the defendant from simply leaving like Ron asked him to do several times. No one was threatening him. No one was restraining him. At any time, the defendant could have walked away from this situation that was getting worse and worse. The defendant simply could have gotten in his car, and if he would have done so, Shadi Dixon would be alive. And Shadi Dixon, his unborn child, would have had his 2nd birthday a couple months ago. But the defendant wasn't having any of that. He wasn't going to just walk away. He was going to finish this confrontation on his terms, his way. And what else is going through the defendant's mind as he's running after Shadi Dixon? As Shadi Dixon's running to the front porch. Every step the defendant is taking, he's developing more and more intent. He's developing more and more premeditation. He's following this fleeing person to continue this confrontation. And now he's got a gun out. Ladies and gentlemen, that's evidence of premeditation. Remember, this 9mm that was found in the front yard is quite a distance from the porch. That 9mm is not in play at all at this point. We have Shadi Dixon and Ron Stewart, unarmed, trying to get away from the situation. The defendant holding a gun, pursuing them. Once they reach the front porch area by the door, that is when the shooting begins. Ron told you, again, he saw the defendant raise the gun, cock it, which again is evidence of premeditation. Ladies and gentlemen, you don't cock a gun and put it around in a chamber just to threaten somebody, just to wave it around. You do that because you intend to use it and pull the trigger. You're readying the gun to be fired. That's evidence of premeditation. Ron told you, he puts his hands up and says, "Whoa, it's not that serious, bro." Puts his hand up to protect himself. That was when the defendant fired the first shot that struck Ronald Stewart. Ronald Stewart was on that front porch, on the right side of that front porch behind, in the area of that right pillar. He told you it felt like something hit him in the chest, knocked him down, he crumples to the ground. After Ron Stewart went down, he hears several gunshots, he hears additional gunshots. And you can see from the body camera footage of Rachel Ward where exactly Ron Stewart was when he went down, and eventually where Shadi Dixon was found, and where she was when she went down and she was shot. The paramedics moved their bodies from that front porch area to the front yard to help allow more access and more movement to be able to have the medical personnel treat them. But they went down on that front porch. And it shows how far they were, that body camera footage shows how far they were from where that 9mm was located. Even after Ronald Stewart told you that after he was shot, he hears several shots and the defendant starts moving around that pillar as we see in the diagram, states 14. The defendant makes his way around that pillar and he's continuing to shoot. He's shooting at Sade Dixon. He's shooting Sade over and over again. And then at some point, after he steps over Ron's body to shoot at Sade Dixon, he turns his attention back on Ron Stewart. Ron Stewart told you that he was laying on the ground, looked up, sees the defendant with the gun pointed at him, and he actually made the decision to rotate his body to avoid that bullet hitting his heart. I submit to you that that is a detail that he wouldn't just make up. That is a detail that he remembers out of pure fear and out of a desperate attempt to save his own life.
Overruled.
We know the defendant was standing almost right over Ronald Stewart when he shot him in the chest. How do we know that? Because the bullet entered his chest. You heard from the body camera footage that there was an exit wound in his back. He was shot in the back. He was actually not shot in the back. He was shot in the chest, but that bullet went through his chest, exited out the back, and actually creates a divot at marker 10 in the concrete with a projectile fragment in it. And in that divot, and around that divot, on the edge of the porch, is a whole bunch of blood.
There was no medical testimony. I move to strike what he just said.
Overruled.
States 2, photo 32, shows you that location of that divot with the blood around it and the projectile fragment. Ron Stewart told you that after the shooting, the defendant fled back to the street where his car generally was. Once he gets to that street, the evidence has shown that Stephanie Dixon Daniels and Dominique Daniels have opened that door, looked out. They see the carnage on the front porch. Dominique Daniels told you he looked and saw the defendant at his car, and he saw the defendant raise his hand. He pulls his mother inside, they shut the door, and 2 more shots rang out. That is the focus of counts 4 and 5, the attempted felony murder. So what additional evidence of premeditation has been presented to you in the evidence in the testimony? Shadi Dixon was disarmed prior to any shooting and prior to Ronald Stewart coming outside. She wasn't a threat. Defendant was told to leave several times before any shooting, but he didn't. He pursued Shadi Dixon as she ran away towards the house, trying to get away from him. Defendant pointed the gun at Ronald Stewart and he cocked it, loaded around into the chamber. Shadi Dixon and Ronald Stewart were a distance away at the time of the defendant when the defendant began to shoot. They were at the front door, he was in the yard area. By his own testimony, he shot from the yard area, and we'll get to that in a little bit. They were both retreating and attempting to avoid this confrontation and get into the house at the time of the shooting. Look at the medical examiner's testimony as well. And the test coupled with the testimony of Ronald Stewart. Shadi Dixon was shot when she was down on the ground. Ronald Stewart told you that at some point during this, Shadi Dixon was kneeling over his body. States 26, medical examiner photos. There are 2 wounds to the Shadi Dixon's leg. One wound, wound F, entered her left thigh and buttock area, and the path of travel, according to Dr. Zadovich, was left to right and upward, and exited out her abdomen, as we see in photo 10 of that exhibit. The second wound, wound H, entered the back of her left thigh, traveled left to right, traveled upward, and exited out the inguinal fold right below where the leg meets the groin area. Exited and then actually grazed her abdomen again. If the victim was standing upright and facing the defendant, there's no way those entrance wounds could have occurred in the back of her body and the exit wounds in the front. It doesn't work that way. If she was standing upright like I am now, there's no way the path of that projectile would have traveled upward through her body. That would mean the muzzle would have had to been below her, or he would have had to be laying down on the ground shooting upwards. That's not consistent. What's consistent is exactly what Ron told you, that at some point she was kneeling over his body and she got shot, which explains why she was shot from behind and the projectile traveled in an upward direction. This is consistent with what Ronald Stewart testified to. It's also consistent with an intent to kill and with premeditation, shooting somebody in the back while they're on the ground. What else do we have? Sade Dixon was shot 8 times. The number of shots and the number of injuries inflicted on Sade Dixon is evidence that this murder was committed with a premeditated intent. The number of shots fired show that the defendant wasn't there to protect himself. He wasn't trying to wound her or scare her or teach her a lesson. He was shooting over and over again at her to try to kill her. He raises his gun first at Ron and shoots him. He then shoots Sade Dixon for the first time. You have heard from Richard Ruth that told you that with this firearm, you have to pull the trigger each and every time. It's not like a machine gun where you pull it once and it just sprays bullets. You have to make the decision to pull that trigger each and every time. And he also told you that he analyzed the trigger pull of this firearm. And this trigger pull was 9.75 to 10 pounds of pressure that has to be exerted on that trigger to make it fire. So each and every time he pulled that trigger, he had to overcome that almost 10 pounds of trigger pull pressure to make that firearm discharge a bullet.
Objection, that's not what he said.
Overruled.
Even if you feel that the defendant did not have a premeditated design to kill at the time he fired that first shot at Sade Dixon, when he squeezed that trigger a second time and shot another shot at Sade Dixon, did he fire that second shot with a premeditated intent? And what about when he made the decision to squeeze the trigger the third time, or the fourth, or the fifth, the sixth, maybe the seventh? Shot him 8 times. Ronald Stewart was also shot, as we talked about, while he was down on the ground. He is unarmed. He's shot once already. He's down on the ground, and the defendant advances upon him, stands over him, and shoots him in the chest. He's not a threat to anyone. He's out of commission. And Ronald Stewart was shot multiple times. The first shot knocked him down. The defendant then turned his attention to Sade Dixon, and then turned his attention back to Ronald Stewart and shoots him standing right over him. That final shot was shot at almost point-blank range directly at Ronald Stewart's heart. That is an intent to kill. That is a purposeful aiming to a vital organ, pulling the trigger, intending to kill. You heard the judge read an instruction on some of these charges that deal with heat of passion. Mr. Gentleman, I submit to you, heat of passion does not apply in this case. The only conceivable evidence of heat of passion comes from the defendant's version of events, where he says Ronald Stewart attacked him. And I submit to you that the defendant's version of events is inconsistent with the physical evidence, with other testimony, and with logic. And we'll get to that later on. I submit to you, ladies and gentlemen, that the evidence is clear and has been proven beyond any reasonable doubt that the defendant acted with a premeditated intent to kill Sade Dixon, that because of that premeditated intent to kill Sade Dixon, her unborn child was also killed, and he acted with a premeditated intent to kill Ronald Stewart. The evidence has proven that he is guilty of counts 1, 2, and 3. Now, the judge also mentioned, and in your packet, there are what are called lesser included offenses, and they are simply just like what they sound like. They are lesser than the crimes charged. The crimes charged in the counts 1, 2, and 3 are premeditated first-degree murder on Ms. Dixon, premeditated murder of her unborn child, and attempted premeditated murder on Ronald Stewart. And what the instructions indicate to you is that you are to look at the crimes charged. And if you find the defendant guilty, it should be for the highest offense which is proven beyond a reasonable doubt. And those highest offenses are the crimes we just talked about. If and only if you feel the state has failed to prove these charged crimes beyond a reasonable doubt, only then would you then start to consider the lesser included offense. I submit to you, ladies and gentlemen, that there's no reason to consider the lesser included offenses because the crimes charged have been proven beyond any doubt that's reasonable. Because they're in your packet, I'm going to briefly address them. Murder in the second degree, as the judge read to you, the state has to prove again Ms. Dixon is dead. The death was caused by the criminal act of the defendant. There was an unlawful killing by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. You can see the difference between second-degree murder and first-degree murder. First-degree murder requires proof of premeditation. Second-degree does not. And because you have these in front of you, I'm not going to read the whole instruction to you. I submit to you, ladies and gentlemen, the defendant is guilty of second-degree murder. But he's guilty of the higher offense of first-degree murder because the state has proven to you that premeditation exists. Another lesser-included offense is manslaughter. The state has to prove that Sade Dixon is dead, that he intentionally committed an act or acts that caused the death of Ms. Dixon, or that Ms. Dixon's death was caused by the culpable negligence of Markeith Loyd. Again, this is a lesser-included offense, and it's something that you should only consider if you find that the main charge has not been proven beyond a reasonable doubt, or a lesser-included crime of secondary murder hasn't been proven beyond a reasonable doubt. Only then would you consider manslaughter. And again, you have these instructions. I'm not going to read them to you. Turning to counts 4 and 5, the attempted felony murder charges. These are similar to the attempted premeditated murder of Ron Stewart, which is in count 3, only it's a little different because one of the elements of attempted felony murder is that the state has to prove that a murder occurred. The murder meaning the murder of Shadi Dixon, the murder of her unborn child, or the attempted murder of Ronald Stewart. In order for the defendant to be convicted of attempted felony murder, you must have first found that the defendant is guilty of a homicide or attempted homicide offense in counts 1, 2, and 3, because that's one of the elements of the crime. If you find the defendant either not guilty of count 1, 2, or 3, or guilty of manslaughter, he cannot be found guilty of attempted felony murder in count 4 and 5. And there's an instruction in your packet that explains this to you. Because the defendant is guilty and the evidence is proven beyond a reasonable doubt, he's guilty of the murder of Shadi Dixon and her child and the attempted murder of Ron Stewart, these counts are also in play. And the evidence has proven that the defendant is guilty of both of these counts as well. These counts deal with when, after the shooting on the front porch occurred, after the shooting of Shadi Dixon and after the shooting of Ron Stewart, he runs out to the street area by his car. Counts 4 and 5 address him when he hears that door open, when Stephanie Dixon Daniels and Dominique Daniels start to leave the house and open the door and start walking out. He decides to raise his gun and pull the trigger 2 more times, right at the door, right at where those 2 individuals walked out. Ron Stewart told you that he fired those 2 shots at the door after all the initial shooting was done, and after his mother and his brother opened the door and walked out, and his mother screamed, "My babies." Dominique Daniels testified that he saw the defendant raise his hand from the street. He pulled his mother in, closed the door, and that's when the 2 shots were fired. The defendant himself told you that he heard that front door open, he took his gun, he pointed at that door where those 2 people were, and fired. In order for the state to prove the attempted felony murder count, the state has to prove that Markeith Loyd committed or attempted to commit murder. You have to have found him guilty of a homicide offense in counts 1, 2, or 3, or attempted homicide. 2, while engaged in the commission, attempted commission, or escape from the immediate scene of the murder, the defendant committed an intentional act that is not an essential element of the murder. In this case, ladies and gentlemen, the murder of Sade Dixon and her unborn child and the attempted murder of Ron Stewart were done. That was over. He had already left them on the porch, bleeding, dying. He had run to his car. Him deciding to point the trigger or point the gun and pull the trigger and fire 2 bullets into that door is completely unrelated to the murders of Shadi Dixon, her unborn child, and the attempted murder of Ronald Stewart. So the act of shooting his gun towards the door where 2 people were just located is an intentional act that is not an essential element of the prior murders because the prior murder has already been accomplished. Count 4 deals with Dominique Daniels, and the state has to prove the intentional act could have but did not cause the death of Dominique Daniels. Well, ladies and gentlemen, we know the damage that a bullet can do. The only reason the reason that bullet didn't connect or hit anybody was because Dominique had the presence of mind to pull his mother in and shut that door. Count 4 has been proven beyond a reasonable doubt. Count 5 is the same analysis, and this count 5 deals with the shooting at the door, Stephanie Dixon Daniels being the victim. Ladies and gentlemen, because the evidence has proven each and every one of the 5 counts in this case beyond a reasonable doubt, we're going to ask you to find him guilty of each of those 5 counts. Because the evidence has proven those 5 counts, there's no need to even look at the lesser included offenses that are in your packet. Ladies and gentlemen, the defendant has testified, and he's provided you with a different explanation of what happened. He has told you that he is the victim here. He told you that he was attacked by Ron, which was the event that caused all of this to happen. That's his version. And we're going to get into this a little more later on when I have an opportunity to speak with you guys again. But when you listen to that testimony, you consider that version of events. The judge read to you an instruction and certain things you can consider when assessing the credibility of the defendant, and any witness. When you assess his credibility and his version of events, the judge told you that you can consider that he's a convicted felon, a 4-time convicted felon. You can consider how he testified. You can consider whether he was straightforward in answering both the attorney's questions when he testified, and he gave this alternative version of what happened. And you can consider whether his testimony is consistent with other evidence and other witnesses that have testified in this case. Thank you for your attention, ladies and gentlemen. I'll have an opportunity in a little bit to stand up and talk to you again briefly. Thank you.
Thank you, Mr. Buxman. Ladies and gentlemen, let's take a quick break before we start the defenses. So 10, 15 minutes. All right, we'll see you back here in just a second.